Hi, everybody. Welcome, welcome. We're just going to give it a few minutes for people to join. We have a lot of people coming in, but we're really excited.
Hey, everybody, we're going to start in just a couple of minutes. Thanks for coming. Okay, thank you so much, everybody, for joining us on this Saturday afternoon. Welcome to Unlock the Bar's first character and fitness teach-in. We have a lot of ground to cover today, so we're going to get started pretty soon. Meanwhile, we're just going to put up the order of events for today. And as you hopefully can find, we have live captioning, and the event will be recorded and posted on our new website within a few days. And we will be welcoming all our attendees to post comments in the chat and questions in the Q&A, or to raise their hand to ask a question live during the Q&A period. And we'll temporarily promote you to a panelist so you can ask a question live. And we'll also share the resources that we're going to be discussing throughout this webinar at the end so that you can access them yourselves. So to kick it off, I'm Al Brooks. I am a 3L at NYU. I use he, him pronouns, and I'm one of the Unlock the Bar organizers, and I will be moderating today, co-moderating along with Tolu, and I'm one of the allied organizers. And let me pass it to Tolu.
Everyone. So my name is Tolu Lawal. I am an attorney and an organizer also with Unlock the Bar. I use she, her pronouns, and I'm an allied organizer as well. I'm going to be presenting and co-moderating a portion of the event. And we just want to welcome everybody to UTB's first teach-in. We're going to engage in a discussion about the discriminatory effects of the character and fitness and ways to approach the issue. We have a lot of people attending today from like paralegals, current and prospective students, attorneys, grassroots organizers, folks who aren't even in the legal field. And so we're not going to assume that folks are coming in with any sort of intimate knowledge of the character and fitness process. And we're hoping to bring all of us to the same space of knowledge in this process. And then also, you know, some of the legal stuff can get a little bit dry. So I'm going to do my best to also inject a little bit of light into that. I have two sort of points to make. One is that when we're saying system impacted, we're referring to anybody who's been involved in or impacted by a state system or a private system, particularly those who are formerly incarcerated or touched by the criminal legal system, those affected by immigration issues, social services, debt collection, etc. And then we're also going to be talking about the New York character and fitness process primarily, but a lot of this information can be generalized to any sort of character and fitness process, and especially the critiques. And so this is the order of the events. We're going to be talking about a history and structure of the character and fitness process, go into legal violations of question 26, which we'll talk about a little bit more later. Hear stories by folks who have been impacted negatively by the character and fitness, go over UTB's goals and concerns, how folks can get involved, our advocacy areas, and then open it up to a Q&A. And we have a lot of folks joining us today, amazing panelists. We have Melissa Ader, who is a supervising attorney with the Worker Justice Project at Legal Aid. We have Mark Ramirez, we have Jess Yuntz, Dieter Tejada, and then we're going to also hear some words from two folks who couldn't be here, but who were impacted by the criminal legal system and by the character and fitness process. And so two folks from UTB are going to read out their statements. All right, and so I am actually going to now kick it to Al for us to get started.
Thank you, Tolu. So for those of you joining and who are unfamiliar with Unlock the Bar, we just want to give you a brief overview of what Unlock the Bar is. Unlock the Bar, which we abbreviate to UTB, is a New York campaign and coalition of movement lawyers, law students, and partner legal organizations. Some folks are system impacted and some are allies like myself, and we're all advocating for a just and equitable legal profession. And the main core of Unlock the Bar are law students and lawyers, with folks from CUNY, NYU, and Columbia law students playing a large role right now. And we partner and connect with legal organizations like the National Justice Impact Bar Association, Legal Aid, and Legal Action Center. And at all times, we are branching out further throughout the state, especially upstate, to the many partners and people who've been affected by this and care about bringing justice into the legal field. So right now, Unlock the Bar UTB is seeking to challenge and abolish the character and fitness process for the disproportionate harm and the deterrent effect it has on marginalized groups, and particularly folks who've been impacted by oppressive criminal and civil systems. So for a lot of reasons, as you'll hear as we talk about today, this process, the character and fitness process and the associated effects of it are extremely arduous and lengthy, costly, and very dehumanizing, emblematic of a lot of the problems that we have throughout our society, but particularly in an explicitly exclusive way in the justice system that's supposed to be bringing justice to people, but instead is reaffirming and reifying harms. And so you'll hear a lot later and throughout UTB's work about how we're interested in reevaluating the legal profession as a whole. UTB started during the Liberation Uprising of 2020, about a year ago, as a response to the chilling effects that state violence and the present structure of the legal profession had on student and graduate advocacy. Specifically, many law students and fresh graduates decided not to participate in protests in the city, or they were, obviously deterred from doing so and intimidated because of the enormous state violence and the effects and ramifications of protests, of uprising that might exist if you get an arrest or if you get anything that they can use against you at the character and fitness process. And there had also been several other groups moving towards increased scrutiny of the character and fitness. We want to shout out St. John's, a group of law students there, and obviously the National Justice Impacted Bar Association has looked into this, and this is obviously something that's been affecting people for a long time. And so this is an issue that there is long overdue change that needs to come to. And around that time also, you may be aware that United for Diploma Privilege had also just kicked off surrounding the bar exam itself. And that movement is challenging the need of the bar exam. And as you may know, there's no need for the bar exam. But it's only one of the extremely exclusive elements of the legal profession's admissions process or exclusive process. And so that's why this is something that's been targeted not only by us, but also by people all around the country. For example, Professor Debbie Mukamal released a report, which is our namesake, in California, interrogating the carceral nature of the character and fitness process. It's called Unlocking the Bar. And in California, a campaign with similar goals launched a few years ago. And after a lot of work, they were able to change their character and fitness process in California. Similarly, Tara Simmons had a law review article in Yale, and Lindsay Lusk has been looking into this work in Chicago, because every state has a character and fitness process. They are built almost entirely on the same exclusive, racist, xenophobic, and problematic processes and perspectives and exclusive elements as there are in every other state. And so they need to be challenged wherever they exist. And a lot of the ground has been and will continue to be shifting in this space. Unlock the Bar is new, we're growing, and we're in the process of being built. And one of the purposes of today's event is to involve more people, and particularly students, in this fight. And another process is also purpose is hopefully to shine a little bit of light on what can be an intentionally dark process. So all of us who are current law students who are going to face the character and fitness, but also everybody generally who needs to understand what this process is, especially those who have been affected by the system and that will give the character and fitness process an excuse to discriminate against you. This is information that people need to have, and the exclusive and oppressive effect of it only benefits from the silence around it. And then also just for all of us who are going to be continuing and joining this work to try to challenge this exclusive and discriminatory process, it's really important that we understand the various structures that keep it up. So all of that will be covered today. And we're going to start with what is the character and fitness broadly. So the character and fitness is a process each state uses to decide who will and who won't be admitted to the state bar, or in other words, who's going to become a licensed attorney in their state based on an assessment of an applicant's character, morality, and ethics. And the assessment is currently in the form of an invasive questionnaire and interview by a member of the Character and Fitness Committee for your jurisdiction. So in New York, the most formalized version of this process happens when someone has taken and passed the bar exam, submits the character and fitness application, and then they go forward through this process. And I say most formalized because there's something to be said about the fact that many law schools on the front end also have questions very similar to the questions asked on the character and fitness as part of their application just to be admitted to the school. And there are similar questions that college applications process and throughout. And so a lot of the disproportionate experience that occurs is on those who are already system impacted. And this happens before even the interview itself, and you'll hear more on that later. But first, I'll kick it back to Tolu, who's going to explain some of the history of the character and fitness.
Thanks, Al. Okay, so how did the character and fitness come to be? Well, the formalization of the character and fitness was really born out of, shocker to nobody, racism, xenophobia, and capitalist pursuits. It's always been a political tool to seek out and exclude anyone who was not an adherent to white normativity. And had really been used almost like an economic system, if you will, to restrict the pool of lawyers in America. And ultimately that served to maintain white control over the functioning and governance of the country. And in particular, the American Bar Association, whose stated purpose was to promulgate rules of ethics and conduct for lawyers, was a huge proponent of excluding Black people, women of all races, immigrants, Catholics, Jewish folks, and anyone else who they consider quote unquote undesirable applicants. So those folks with radical politics, it's like nobody from CUNY would have gotten in. And so basically what that means is that anyone who was a white Anglo-Saxon Protestant, anyone who was not a white Anglo-Saxon Protestant was presumed to have a wayward morals. But the story of the character in fitness is really a story about the development of the legal profession itself. There had always been some type of character assessment because people really did not like lawyers. They thought that we were cheats and opportunists. And so early on, legal professionals developed this deep interest in shaping and protecting a lawyer's image, though clearly they did not get that far. But what's really important is for us to start off with the fact that prior to the 1800s, lawyers were not an organized entity. They were farmers and theologians and fishermen and politicians and merchants. And the way that they got into the profession was through apprenticeships. And so, that was someone who was already a lawyer taking somebody who wanted to be a lawyer under their wing, and you learn that way. So law schools that we see today really didn't exist until the late 1800s, and it really wasn't until 1941 that law schools required 3 years. So apprenticeships structured the law, and what that means also is that almost all the laws in this country until about the last century were created by people who did not go to law school. And apprenticeships were also heavily racialized. White lawyers would give knowledge, access, and power to fellow white people under their tutelage. And a lot of for example, a lot of anti-Black laws and policies and culture really tightly restricted Black access to apprenticeships, seriously limiting avenues for Black people to become lawyers. As industrialization takes over the US, the law begins to develop really rapidly. So there's a lot of commerce to go around, there's more industry, so there's kind of more need for more lawyers to organize all of that property. And so we really begin to see a democratization of the law. There are more and more people coming in, and more people are getting access to the knowledge through the decline of apprenticeships and the rise of legal academic spaces. But a lot of Christian white males did not want more lawyers for several reasons. So firstly, that would make their fees drop. But also they believed that white men were the only people who had the quote character to be lawyers. Wait until my later segment. So we see that they created a lot more restrictions and regulations and structures in order to stop people from being admitted. And if we pay attention, so as we go through this timeline, as we pay attention to the political climate and the attempts at entry for people who are marginalized, we really see the legal profession and the character requirements take off. So in 1820, we see the first Indigenous lawyer admitted to practice. 1844, we see the first Black lawyer. And we also start to see modern law schools form in the mid to late 1800s, which is a double-edged sword. So on the one hand, knowledge is more accessible. And at this stage, many more Jewish folks are able to become prominent lawyers. But on the other hand, law schools attempted to discourage non-white male applicants from joining and attending the school. So for example, in 1868, Columbia University founder George Templeton Strong wrote that, quote, "No woman shall degrade herself by practicing law in New York, especially if I can save her," end quote. And aspiring Black lawyers were restricted from attending white law schools, and so really had to create their own law schools. Black women faced intersectional harm, often excluded from both white law schools and Black law schools because they were women. And so it really took until 1872 for the first Black woman to practice law in the United States. But at this point, however, law schools are still not yet required for entry into the profession. So we start seeing bar associations pop up, and they kind of act a little bit like cartels. They're really trying to restrict the access to the profession and essentially rendering it really hard for you to practice the law if you weren't a part of them. In 1878, the American Bar Association was founded. The ABA literally began pushing states to make law school a necessity before practicing, partly another stopgap for Black and Jewish and other immigrant lawyers from accessing the profession. Between 1880 and 1920, states began to adopt a lot of character entries. And between that time, we really see a lot more Eastern and Central European immigrants coming into the country. We also start seeing questions pop up on the ABA admission applications for race and gender, because in 1912, they, quote, accidentally gave admission to 3 Black people. So they were like, we can't have that happen again. And they began to put on these these exclusionary boxes for folks to check in. In 1929, the Great Depression hits, and those economic realities create further restraints on the access to the profession, but also the gatekeepers searching for new classes, are starting to search for new classes of people to restrict. Oh, sorry, I have to go back. And in 1931, the National Conference of Bar Examiners formed to create uniform standards for the admission. They continued to drive stricter admission requirements. And in 1941, the ABA stated that you have to graduate from an ABA accredited law school in order for you to sit for the bar exam. So what's really important to understand about character tests is that they were primarily anti-Semitic and xenophobic. They were used by white male Protestants to try and stop Eastern, Central, and Southern European immigrants alongside Jewish and Catholic folks from entering the profession. And the reason it was specifically targeted to this group of folks is because, unfortunately, they knew that Black folks had many other legally sanctioned ways of being denied access. For example, poverty and restriction from educational opportunities left many unable to meet whatever bar entry requirements existed. So when it fell out of fashion to be openly discriminatory, we also begin to see a rise in the difficulty for entering the profession for those that white society essentially looked down upon as castaways. You see this Deborah Rhodes quote over here. Deborah Rhodes, she's a professor who really studied this and wrote a seminal work on it in a Yale Review article. And she talks about how during the Great Depression, this group of folks really started to be seen as those that the white society wanted to exclude from the legal profession. And then during the height of McCarthyism, we start seeing them, exclude folks who are considered quote unquote radical. So there's this case, the Supreme Court case called Schwer versus Board of Bar Examiners, where the petitioner was rejected from the New Mexico bar in 1953 because he disclosed to his investigating character and fitness committee that he used different aliases for 5 years and had once been a member of the Young Communist League. But for him, as a Jewish person facing intense discrimination during the Great Depression, he had to take on aliases so he would actually be able to work at some of the employment opportunities available. And he also joined the Young Communist League to better advocate for labor rights and was subject to political arrest. This case is actually ends up being good for us. The Supreme Court rules favorably there that any qualification of good moral character has to have some rational connection to the applicant's fitness or capacity to practice law. And so also for folks who are formerly incarcerated, it's not a surprise either that folks would have a really difficult time coming in. In 1976, Walter Gellhorn, who's the late Columbia professor, had once written that for professional licensure requirements, formerly incarcerated folks are presumed to have bad moral character, quote unquote, and so are essentially kind of categorically excluded from receiving any sort of professional licensure. So when we look at the way that the character and fitness process became formalized and understand that it had really been a tool for exclusion and racism and white supremacy, it makes a lot of sense how the character and fitness process today affects folks who have been affected by the same systems that white supremacy creates. So now we're going to go into the overview of the character and fitness structure. So what laws authorize the character and fitness in New York? What's on the application, who is the character and fitness committee, and what is the current character and fitness process like? So I'm not going to necessarily go into all this deeply, but there are a few relevant laws and regulations that establish the character and fitness process. So there's Section 53 of the Judiciary Law, which it says for the Court of Appeals that they have the ability to create rules and laws and regulating the admission of attorneys. Section 90, which is probably one of the most cited of judiciary law, which says for the appellate division that they are the ones who are responsible for appointing the character and fitness committee members. There is Rule 9401 from the Civil Practice Law and Rules of New York that establishes the character and fitness committee, and Rule 9404 which is probably one of the most important and most relevant laws for our sakes, establishes the character and fitness. And what's interesting also is that it doesn't actually say that the character and fitness needs to look the way that it does today. It really only says that you need to be evaluated and investigated and approved by a character and fitness committee of the appellate division in some kind of way. Then we also have rules and regulations, the New York Code rules and regulations. And so the Court of Appeals has a rule, has a regulation which states that, it requires the proof of moral character before entering the bar exam. And then the first department through the fourth department have their own regulations as well as to how to conduct the character fitness process. And all of them look exactly the same, essentially. So now we're going to go into the structure of the character and fitness, what's on the application. So amongst other things, the application for admission requires you to submit a questionnaire. You have to give 2 original employment affirmations or letters. You have to give original employment affirmation or letter for each law-related employment, 2 original affirmations of good moral character. And this is, I want to really just take the time to go through this one because it's a little bit ridiculous. The affirmations have to be from folks who are quote unquote reputable, who have known the applicant for at least 2 years, who's not the same person as the people who are giving your employment affirmations, not your present employer, not anyone related to you by blood or marriage, not any of the other applicants, and not members of your faculty or administrative staff of any law school attended by applicants. So I'm not entirely sure who that really leaves, but you have to get 2 original affirmations of good character. And then there's also a form that law schools send themselves where they kind of can note any sort of flags. And then there are any other papers that you would like to submit. Okay, so what is the questionnaire? So this questionnaire is essentially kind of like the main part of the character and fitness, or at least the main part that we really are trying to interrogate. It's incredibly invasive. There are a lot of questions that bear no relevance to the practice of law, and it's honestly a little laughable, some of these questions. And this already significantly disadvantages those with records and complicated personal histories. And many of the questions are really carceral in nature. So we're going to take a look actually at some of the questions. I pulled out some of the ones that I think were particularly invasive and utterly ridiculous. So we have a section that looks into school issues. So you see question 11 is asking if you've ever been denied admission from from a school, college, or a law school, or any other similar institution for stated cause that might reflect upon your character. Question 12, I think this one is really rich. It asks if you've ever been placed on probation, dropped, suspended, or expelled, or otherwise been subject to discipline from any institution above elementary school. So I guess they really want to know if you've ever been placed in timeout, I guess. Then there's question 13, which asks if you have ever been requested or advised by any college, law school, or other professional graduate school for any reason to discontinue your studies therein. Then we also have the employment category. This one is very extensive. They really, really are serious about asking you to list every single employment you've ever had since the age of 21 or the last 10 years, whichever is shorter. And they include a whole swath of what they mean by every employment. And so that includes if you've worked for your mom or your dad. It includes if you worked without compensation, monetary compensation, any law-related or work-study employments, for academic credit, things like that. So it's very extensive. And then they also in question 16, ask if you've ever been discharged or requested to resign from or leave your position in any kind of way. Then we have question 26. As of December 2020, it's question 26. Before it was question 27. And this question is particularly of interest for Unlock the Bar and our allies and our partner organizations. And we're going to talk a little bit more about that a little bit later. But this is the question that's particularly carceral. It wants to know if an applicant has had any sort of involvement or interaction with law enforcement or the criminal legal system So it asks if you've ever been cited, ticketed, arrested, taken into custody, charged with, indicted, convicted, or tried for, or pled guilty to the commission of any felony or misdemeanor, or the violation of any law, or been subject of any juvenile delinquency or youthful offender proceeding, and it asks for adult and juvenile records. The only thing that is, I suppose, nice is that they just didn't ask for your parking tickets. So very invasive there. Then we go into civil matters. So they want to even know your civil testimonies, if you ever testified or refused to testify or been granted immunity as a complainant, a party, or a witness in any action or proceeding, or in any investigative or excuse me, before any prosecuting or investigative agency in any matter. They asked if you failed to answer to any ticket or summons. Okay, sorry. So this is where they ask for the parking violation. So they want to know if you have any unpaid parking tickets or traffic tickets. And they also want you to state whether you have been a complainant or party or witness to any civil or criminal action or proceeding that was not covered by any of these other questions. This is an old question. This question is no longer on the character and fitness. This is a 2019 application, but we really wanted to put it up just to really underscore how invasive the character and fitness is. And so they did ask at one point for mental health conditions, and they were extraordinarily invasive with asking this question. They removed this, and so that is relatively okay, except for the fact that in the new app, they actually have a catch-all question that sort of alludes to this, to the old question, unfortunately. And then we also they also want you to note if you use any illegal drugs, which I'm like, why would we even say yes to that? I'm not sure. They also have a question asking about child support. So they want to know whether or not you are in arrears in your child support payments. So again, this is extraordinarily invasive. It has no relevance to your ability to practice law. And then there's also another question as well, asking if you owe any debt for $300 or more. Again, what relevance does it have to law? Nobody really knows. And then after all of this, then they still want me to pledge allegiance to this country. So it's very confusing. But one thing to note actually for question 44 is that for folks who are in liberatory organizations, which the state might for some reason consider a subversive organization, this question might be causing some issues for some folks. So now let's just go into the process of the character and fitness. So what does it look like for an applicant to go through the process? So typically you pass the bar exam, you file your application to the relevant jurisdiction, you have your character and fitness committee interview, and then you're either admitted, denied, or deferred. For somebody who doesn't have any, quote unquote flags, and when this was in non-COVID times, folks would sort of all process down to on a particular day to an administrative building in order to get interviewed by a member of the character and fitness committee. And typically those interviews would roughly take between 2 and 5 minutes. And it honestly was just a formality. And if you were admitted, the committee member would recommend you to the committee chairperson for certification to your respective appellate division. And then you pay a fee. I think I paid something like $400, and then you get sworn in. But for folks who have quote unquote flags, if you have a criminal record, if you have financial issues, some academic discipline, it's a lot more difficult. And so many impacted folks will still have a one-on-one interview, but it lasts a lot longer, upwards of an hour. Often the questions and the comments and the treatment during those sessions can be offensive. Many folks get their matter kicked up to a subcommittee of at least 2 members of the character and fitness, and then they set up and conduct a hearing that actually kind of mimics a trial. So we have narratives of folks having to hire attorneys, relitigate already adjudicated cases, find records from decades past. Some people had to submit hundreds of pages of documents, taking on additional costs and expenditures. They're subject to inappropriate and aggressive questioning, and honestly kept in the dark really with this whole process. And it can take years before someone with a record is admitted, and sometimes folks spend all of that time and then they aren't admitted. So who is the Character and Fitness Committee? They are one major set of gatekeepers to the profession, if not the gatekeepers to the legal profession. They really shape the image of the profession, what the profession is, what it's supposed to be, quote unquote, what it should and shouldn't be, because they select who's allowed in. But who is on the committee and how do they get appointed? Honestly, nobody really knows. We know, of course, that they do get appointed by the appellate division, but we don't exactly know, who chooses them to be appointed. It's a very secretive process. And you can find a roster online, but we do, for some of the divisions, but you don't really know, what year that is, how long people have been serving in the committee, anything like that. Are they racist? Can we trust them? How are they reviewed? We know that it's a group of volunteers, and we know there has to be at least 3 practicing attorneys. But Carol M. Langford, who's a professor who studies some of this or has written on it, talked about how a majority are from large and medium-sized firms, and so a lot of they sort of necessarily limit the diversity of views represented in those committees. I think one thing that we figured out is that it's some combination of the appellate division, the board of law examiners, and bar organizations that are sort of selecting who gets put onto these character and fitness committees. So ultimately, the entire character and fitness process is really not transparent. It's arbitrary, it's political, there is no standardization at all. Often you're subject to the mercy of the one attorney who gets assigned to you, and their determination of your quote unquote fitness to practice law. What things will lead to a one-on-one interview, what things will lead for your one-on-one interview to be passed onto a subcommittee, who is on the subcommittee, what are the numbers of the people who get denied, what's the length of the time spent for folks who are formerly incarcerated to go through the process or financially encumbered or do liberatory work. We really don't know. Those numbers are really hidden. And oftentimes a lot of folks are not able to challenge these powers because because a lot of applicants have to walk on eggshells around them because they don't want to incur their wrath. And a lot of attorneys who are established may know somebody who's on the character and fitness committee and may not want to run afoul of them. So there are many reasons why this process sort of doesn't get any light shined on it. And there's a lot of fear of retaliation. And oftentimes when we try to get more information from the character and fitness committees or the courts, they might be able to actually claim an administrative exception. So essentially saying that if they are, essentially saying that they don't have to release the information because they are an administrative agency. So I have this quote up here from Professor Sean Hopwood, who is a formerly incarcerated person who has also worked through the character and fitness process and worked on it, and talks about how, the more he looks through this whole process, the more it feels arbitrary, often because the people who are making the decisions on the character and fitness committee are not folks who have been touched by the criminal legal system, and who don't know the collateral consequences of folks who are coming out of prison or who have been system impacted in general. So now I'm going to actually pass it to Melissa Ader from Legal Aid, and she's going to talk about the legal violations of question 26.
Hi, everyone. I am the supervising attorney of the Worker Justice Project at the Legal Aid Society. And the Worker Justice Project, we work with people who have arrest or conviction records and are being denied jobs or licenses because of those arrest or conviction records. And we work on this for a variety of licenses all across that really run the gamut. But a few years ago, we became very interested in law licensing, and that is what bar admission is. It's it is a license to practice law. In New York State, there are a variety of laws that protect the rights of people who are applying for licenses and have some kind of criminal record. When I say criminal record, I mean any record that began with an arrest or a summons. And so you have criminal records in the adult court system, and then juvenile records in the family court system when somebody is arrested for juvenile delinquency. I don't know if it's possible to go to the next slide. So I'm going to be talking very briefly about two laws. And the reason why I'm focused on these two laws is these are the laws that question 26 expressly violates. And these laws were enacted by New York State in order to ensure that people with arrest records had a fair opportunity to obtain licensure. And they were also passed to ensure that people who were applying for licenses didn't have to be asked invasive questions about certain categories of criminal cases and all juvenile cases. The laws really were, they're not just about reentry, they're also about protecting people from embarrassment and saying after a certain point, if your case is resolved in a particular type of way, you should not be answering questions about this type of case anymore. So the first law that I'm going to talk about briefly is the state human rights law. And there's a specific subdivision of the state human rights law, subdivision 16 of section 296 of the executive law. This law applies to adult arrests. What it says is that with respect to licensing, it is unlawful for the government to inquire about, require disclosure of, or discriminate on the basis of a criminal case that falls into one of the following 6 categories. I'm not going to go into the categories extensively, but the first type of category is cases that are dismissed and terminated in a person's favor. Some of those people never even went to court. The case was dismissed before the prosecution began. The other important types of cases are cases that are adjourned in contemplation of dismissal, youthful offender adjudications, which are cases where a person pled guilty, but the judge determined that they should be adjudicated a youthful offender because of their age at the time of the offense and other related factors. And then sealed convictions. So a violation level conviction that is sealed, or a criminal conviction that is sealed under various types of sealing laws. The state human rights law exempts gun licensing from this purview, but there is nothing in the state human rights law that exempts law licensing from this law. It is clear that the bar should not be asking about cases that are finished in one of these 6 ways. And nevertheless, question 26 expressly states that a person needs to disclose every single arrest they have ever had, even if the case was sealed, even if the case was expunged, even if it resolved with a youthful offender adjudication. It is hugely problematic and illegal. And the second type of cases, the second law that I'm going to talk about very briefly, if you can just switch to the next slide, are juvenile cases. So when somebody is arrested as a young person and they are charged with a juvenile delinquency arrest and they are brought through the family court system to face that juvenile delinquency charge, the Family Court Act, which is another New York State statute, says that it is unlawful for anyone to require that person to divulge information about their juvenile delinquency arrest or the subsequent juvenile delinquency proceeding. The law also says that the juvenile delinquency adjudication shall not disqualify the person from obtaining a license. But again, I actually think the most important part of both of these statutes with respect to bar admission is that the inquiry itself is unlawful. Back in 2017, Legal Aid reached out to the character and fitness committees because we looked at question 26 and it was clearly unlawful, and we were hoping that they would be willing to change the question so that it looked at other types of criminal cases that they are legally allowed to look at, but not these off limits types of juvenile and criminal cases. And the reason we were focused on this very sort of narrow area of juvenile and sealed criminal cases is because it's expressly unlawful for the bar to be looking at these types of cases. We wrote a letter in 2017 to the character and fitness committees, and it's our understanding that they reviewed the letter, but our advocacy in that letter and subsequently was unsuccessful. The bar did change question 26 sort of, but instead of changing the substance of the question, what they did was add a preamble to the question. And the preamble seems to imply that the bar thinks that they do not need to abide by these laws, that section 90, the statute that governs bar admission, somehow exempts them from these laws, which I believe does not exempt them. And so it was troubling, and we're hoping to work on further advocacy, but we're really excited about the Unlock the Bar movement, both because we're hopeful that it will persuade the bar to begin abiding by these very express prohibitions on the inquiries that are being made, but also because we're excited about Unlock the Bar going farther than this and talking about unsealed criminal cases, criminal convictions for which a person served time, et cetera. One other thing I just want to mention is the bar is the only licensing agency in New York State, other than gun licensing agencies, which are expressly exempted from these laws. The bar is the only licensing agency in New York State that systemically violates these laws and says that it does not need to abide by these laws. Doctors, for example, doctors are licensed by the State Education Department of New York State. The New York State Education Department abides by these laws, at least systemically. The Department of Financial Services provides banking and insurance related licenses, and the Department of Financial Services abides by these laws. Accountants, for example, they're licensed by the State Education Department, which again abides by these laws. So the argument that the bar, being a lawyer, is somehow different from these other occupations is both troubling and irrational to me. And I'm hopeful that that there can be a change. And I'm just really excited about this movement, and I'm excited that all of you are here today. Thanks.
Great, thanks so much, Melissa. All right, now we're gonna hear from folks who have been impacted. I'm gonna kick it to Al to start facilitating.
Thank you, Tolu and Melissa. So yeah, as we said, and you probably may already know, there are a lot of people who've been impacted by this and who've been working on this issue or been fighting back or have their own narratives. And so we're gonna hear from a bunch of great, wonderful people who have volunteered their time and their stories. And to start us off is Mark Ramirez. You can step up to the stage. Thank you, Mark. Mark from the Bronx Defenders, shout out the Bronx, shout out the Bronx Defenders. I said a few questions to you about your story, and I was hoping that you could talk to us a little bit about it. First, just to start off, I was wondering if you could talk to us about just everything you had to prepare even before the character and fitness began. Just before the process.
Hi, good afternoon, everyone. Thanks for having me. So just to start out, going way back, right? So when I was incarcerated, I guess I should start from there. I have a felony conviction, a drug crime I committed when I was 18 years old. I got locked up in the feds and spent a long time there. While in prison, I started spending a lot of time in law libraries, so doing some of my own legal work, and decided then that I wanted to be a lawyer. I didn't know at the time whether I could actually be a lawyer, but I guess I decided I wanted to go to law school. I had been living the law, to say, and decided I wanted to practice the law. And as I was just saying, that I wasn't sure that I could actually be an attorney, but I felt that I can go to law school, get the training, and even if I wasn't allowed to represent people in court, I could still technically practice in the background somehow. Fast forward, I get out, I finished my undergrad, I start applying to law school and I'm doing research to see if I can actually get a law license, a licensed practitioner. And I realize I can. And, then of course that's the goal, right? To get to law school and to practice. I wasn't exactly sure what I was going to do, but I knew I wanted to work in the public interest. So that's why I went to CUNY. But even that was a process, right? Trying to figure out where I wanted to go, who would admit me, telling my story, because there's barrier upon barrier upon barrier through all of this. So I guess, not I guess, I just made it a point to tell my story in a way that was very sympathetic. I was 18 years old when this happened, made a mistake, cost me a lot. So, I was hoping that people would see that, I was changed. And that was, I guess, the biggest thing that I wanted to show both the law schools and eventually the character and fitness community, that I was a very different person. I was an adult now. I thought differently and didn't want to contribute to anyone's downfall, which I felt, being part of drug transactions was. Do you have more specific questions? Should I just keep going? Go ahead.
No, that was wonderful. Thank you so much for giving us that background. One of the things that that I wanted to hear about too, and might be helpful for other people, is just can you explain your experience getting an advisory opinion?
So, I didn't get an advisory opinion. Actually, you're going to hear from Roland a little later, I believe, and I had contacted Roland through a mutual contact, and it was kind of and it was Roland. Some other people told me, like, there's no point in getting an advisory opinion. I guess you can get an advisory opinion before going to law school or while in law school. But it just doesn't make sense, right? It gives the character and fitness committee kind of two bites at the apple. It's highly unlikely they're going to give you a definitive answer, that says, yes, we'll definitely admit you, without actually going through the full process or graduating from law school just yet. Why would they, right? It's a process that they want you to go through, so they're going to make you go through the full process. They're not going to tell you up front, we'll definitely admit you. So it's probably just going to be what we already know, right? That there's no absolute bar due to a criminal conviction. So we know that we've seen cases on the books with that. So there's no real point in seeking that advisory opinion.
Thank you. So what did you actually decide you wanted to bring into the character fitness process itself? Like, what were the things you prepared?
Well, I made sure that they asked for 2 character affidavits, which Tony talked about a little earlier. I made sure to give them more than 2 dozen. I don't remember the exact number, but and I got them from professors and people I had worked with, because I worked at the Bronx Defender before going to law school in a different capacity. Law school professors, college professors, a judge who was one of my professors, a judge I'd interned for, friends, social workers, someone who worked at one of the prisons I was at for a while, who retired. She wrote me a character affidavit. I just wanted to show them that also, I want to show them that I had changed. So I also gave them a long list of all the things I had done while I was in prison and since I had come out of prison, to show that this wasn't like just stuff that I wanted to do or started to do once I realized I was going to have to go through the process.
Yeah, and then can you talk to us also just about what the process itself was like?
So, so yeah, just filling out that long, I don't remember if it was like 20 pages application. And the affidavits had to be within, I think, like 60 days or 30 days or something like that. So it's kind of like coordinating with a lot of people for them to be ready to execute and send the affidavit within a short period of time, so I could put it all together and submit it to the character and fitness. And I think what was really hard for me in the application was just trying to figure out what they were really asking in some of these questions, like what they really want to know. Well, I said I just explained I wanted to show them that I had changed. What I was trying to figure out, was this enough, or what of the things that I'd done and would express that to them. And of course, there's no way to completely figure it out, because after I submitted all of that, they also came back with some other questions that kind of blindsided me. One of them in particular was about school discipline. I had been on probation in undergrad before I went to prison, and they brought that up. I had actually been on probation before and after I'd gotten out. It was academic probation, and I at some point got dismissed from the college, all for academics. And the question asks if you've ever been dismissed or disciplined or the like due to anything that would reflect negatively on your character. So I didn't think just being a bad student would reflect negatively on my character. So I didn't answer it. And I don't know where they got this information, but once I got that question back from them, and there were some others, I just don't remember off the top of my head, I made sure to completely disclose. So I pointed out that I had not only been on probation once, but several times, and I had been dismissed, but it had all been based on academics. And I got a letter from the school, and the letter from the school specifically said they had no information that would reflect negatively on my character.
Thank you so much for sharing all that. I really appreciate it. And we all do. One last thing, I just wanted to see if you had any other suggestions or advice you'd like to share with everybody else for people who are interested in applying to law school now, or who are preparing for the character and fitness generally.
I think the big thing is to get your school behind you. With my initial law school application, and the school really backed me on everything. I was worried like that they were going to make a big deal about something. There was another case. I'd been arrested again, and I just put down my arrest charges because it really went nowhere. And then speaking to someone else, they were like, yeah, you have to explain kind of the process. So then I gave them a long explanation. And my school just, they were like, you know, we would admit you anyway. And this was kind of like a warning for me going into character and fitness, that to fully disclose so that there's no question, right? It's a whole lot easier to address what everybody knows than to try to explain something afterwards. So, and it's kind of some of the work I want to do on the side to help people who are looking to be admitted and feel they may run into some character and fitness issues. I was helped along, Roland helped me along, so I'd like to help the next group along and see how we can get more people into this practice while we still have this process in place, and hopefully we can change this process so that it treats us differently, more humanely.
Thank you so much, Mark. I really appreciate that. Thank you for your time. And as we said before, we'll have a Q&A process at the end. So if anybody has any more questions for Mark, you can definitely shout them out. And let me pass it off to Tolu.
Thanks.
Thanks, Al. Thanks, Mark, so much. Next, we're going to hear from Jessica Younes. Jess, if you want to put your camera on. Great. Awesome. Hi, Jess. So we've talked before, actually, and you've had a particularly traumatic character and fitness process. And I also think that there's a gendered element to it. I think that the level of offensiveness really felt like it came from the fact that you're a formerly incarcerated woman. So could you share a little bit about some of the comments and the questions that were directed at you during your character and fitness process?
Sure, absolutely. So I guess, well, I have a felony conviction from over 20 years ago. So obviously I went into this process of being formerly incarcerated. And I went through the process you talked about earlier, where I had an initial interview and then it was sent to a subcommittee, which are 2 people. I remember in my initial interviewing being asked if my children all had the same father. I remember at the subsequent hearing being asked what I eat for dinner the night I was arrested, and actually being criticized because I couldn't remember. And it's funny because I didn't have the money to take an attorney with me, so I couldn't hire anybody. I went in myself, and I went in giving myself the same advice I would give a potential client. Be respectful, be honest. If you don't remember, it's better to say you don't remember than to give inaccurate information. So I went in that with that, attempt. And so to be criticized because I couldn't remember what I ate for dinner the night I was arrested, I thought was pretty interesting. What else? I remember this actually became a condition of me being admitted. They asked how I could have gotten through everything I've been through without seeking help from a mental health professional or becoming addicted to drugs or alcohol. And they actually made that a condition, saying that they wanted a mental health assessment to be done. And they wanted to end the hearing at that point, and I asked if I could at least put all my accomplishments, like Mark talked about. I had a list of everything that I've accomplished, because again, this was so many years ago. And they said yes, and I turned to the court reporter and basically just went through the list to the court reporter. I wasn't even communicating with the hearing members. And at one point I went and said that I had been a delegate to speak at the United Nations in Geneva. And one of them said, they asked you to be a delegate. And I don't even know who said it, because I was turned towards the court reporter. And I just remember thinking, wow, I like, is this really happening right now? And so after the hearing, again, they made a condition that I seek a mental health professional, which I agreed to. I said, if that's what you want, I would go do it. And then they wanted the notes. And I said, I'll agree to the assessment. If you want me to be seen by a mental health professional, I have no problem giving the assessment that the mental health professional provides, but I don't see why you would need the notes. And they said I ultimately denied my application after 5 years, but said that because one of the reasons was I didn't agree to the release to the notes.
Thank you for sharing that. Not only are all of those questions so utterly irrelevant, they're clearly sexist and obviously really traumatic. And you mentioned also earlier that there was a court reporter, so that means like a lot of this happened on the record too, in the court. Yes, I couldn't get a copy of the court report, the court record, the transcript, because I didn't have the funds at the time, but they would be provided it. But if you want a copy, you have to pay for it. So it's like a really weird level of sanctioning too from the court that they're comfortable saying all of this on the record. So how long did the entire process take for you for the Character and Fitness Committee? And also like what kind of decision, I'm sorry, I didn't mean to cut you off, but what kind of decisions also did you make? So the whole process took almost 5 years. I passed the New York bar in 2011. I remember I got the letter denying me in July of 2016. So it was just, almost 5 years, which I think that's how long your score is good for, which is ironic. But there was a lot of back and forth in between. I had got my rights restored here in Florida in, I believe, 2013. I had sent them the information. It would go 6 months not hearing from them. And then they would say, oh, we didn't get this. And I would send it, and then another 6 months. So it was a long process. And at the time I owed over $200,000 in law school. So I decided to go back for my PhD. And they ultimately used that against me as well, saying it wasn't fiscally responsible for me to go back to school, knowing how much I owed for law school. And I did that after 4 years. I started
the PhD program in 2015. So I had waited a couple of years. I didn't go right into it, but the process has taken so long, and I was a single mom making $15 an hour and just wondering what I was going to do with all these loans and how I couldn't even afford a place to live. Thank God for my dad. I was able to stay with him, because even with not even affording some place to live, everywhere you go, they have felony restrictions. So.
And you had mentioned that they ended up denying you ultimately. And so did they extend a reason for the denial?
The primary reason was not abiding to the requirement to see the mental health professional, and which is not true, because I did agree. I just didn't agree to the release to the notes. And they used the not being fiscally responsible. And I think they said I didn't submit a credit report, which I did. So again, they're looking at my debt again, which, not understanding the collateral consequences of being formerly incarcerated, which only contributes to that, because you don't make as much as the counterparts, you don't, have the same opportunities. So all of that impacts your debt.
And also, were there any sort of after effects of the denial?
Sure, absolutely. Well, for one, I walked out of that this is one of the worst, even after all I've been through in my life. That was such a traumatic experience. I just remember thinking, I wouldn't want that on my worst enemy. It was just so traumatic. And I really put off applying to the Florida bar because of knowing what I'd have to go through, just like I did with New York. But what's funny is recently my friend had said, oh, just take the Florida real estate exam with me. So I looked at the application, and on the application, it asks if you've ever been denied a license from any association, jurisdiction, or whatever. So if I answer that, I'd have to say no. I mean, yes. And that could potentially impact the decision of whether or not I could sell real estate. And I got denied in 2016. So that's how many years ago for a conviction? That's over 20 years ago.
Right. Do you have any other, thank you so much for sharing your story. Do you have any other thoughts, maybe any advice for anyone?
We just got to attack these practices and policies. I mean, not only do they impact the people that are impacted by the criminal justice system, but I can just think about the impact it has on my children. It's generational. My children grow up in the financial circumstances they did because it's something I did before they were even born. And now that lays the groundwork for their children. So, it's definitely a generational impact that we really need to consider, but the practices are discriminatory in policy and in practice.
Great. Thank you so much, Jess. Really appreciate hearing your story as well. Great. So next we're going to kick it to Hadia, who is going to be reading some words from somebody who couldn't be there with us today, but wanted to share.
Hi, good afternoon, everyone. We had spoken with a New York State student who was arrested at a Black Lives Matter protest while in law school, and they wanted to share on the panel, but asked to remain anonymous due to their pending case, but still felt like it was really important to share this perspective. So I'm going to read that to y'all now. The character and fitness portion of the bar is suddenly a new concern for me, even though I came to school without a record. As a person of color, growing up with regular encounters with the legal system and near arrest, it was a relief to reach this point. I was arrested while doing what I think lawyers should support, which is exercising and helping others exercise their First Amendment rights. The unfortunate outcome is that I, and I think many other law students, decide not to participate in things like demonstrations, for instance, in order to avoid getting in trouble and further to avoid any issues on the character and fitness. The result being what the police want, which is to stifle speech and put down certain classes of people. The bar ends up being an extension of this oppression, and the legal world an extension of that. Mentors, professors, fellow law students, even my own lawyer, discouraging activism in some instances, and any sort of radical protest in most cases, which sterilizes and stifles the legal profession. Would-be radical-minded lawyers, in turn, avoid even applying to law school, and law students, if they aren't already, are brought into submission over the course of those 3 years, the looming character and fitness, a sword of Damocles preventing them from hitting the streets. The legal profession then remains, as it is, the conservative and elite institution it's meant to be. Mission accomplished. Although I was arrested doing what some would consider good trouble, I initially thought everything would be fine regarding character and fitness. My lawyer even warned it would be an issue when I'm before the panel. I still don't know how the character and fitness will see it. The whole process remains a mystery to me, and it's very much a concern. We're really grateful for this anonymous statement. And with that, I'm going to pass it to Jahari, who's going to read another statement from someone who couldn't be with us today.
Hi, good afternoon, everyone. I'll be reading some tips from Roland Acevedo, who is a formerly incarcerated attorney here in New York, who's worked to advise people through the character and fitness process for over 25 years. So the next words you hear from my mouth will be from him. If you have a record, the single most important thing to submit on your C&F application is the statement explaining your contact with the criminal justice system. That statement has to be forthright and not attempt to minimize any criminal conduct, while at the same time you have to try to convince the committee that you're a changed or repentant person. For those applying to law school now and those currently in law school, the committee will almost always have your law school application too, which will usually also include an explanation of the criminal conduct. This is where most applicants struggle. The two statements often do not match up. There are omissions or additional facts, etc. Though this is of course natural due to the amount of time that's passed, the committee always hones in on discrepancies in any old or new statements. Now, although you may not need an attorney to move through the committee, if your case gets kicked up to the subcommittee, you'll want an attorney. An attorney cannot properly assist someone with drafting a statement to the committee without first seeing the law school applications, their full records, and any accusatory instruments that were issued in connection with the criminal conduct, such as a complaint or an indictment or something like that. If you have a record that involves some form of violence or weapons, you will almost certainly get kicked up to a subcommittee. If you have what you might consider a complicated case, you'll want to hire an experienced attorney. So those are the things that Roland suggests. And something that we also want to add is just that in general, for anyone who might have any concerns, it can be really useful to consult with an attorney before you submit your application to the Character and Fitness Committee. Now, with all of that said, I'm going to pass it on to Dieter Tejada, who is the co-founder and executive director of the National Justice Impact Bar Association. Dieter?
Johari, thank you. All right. I have 5 things. I know we're going to have a Q&A at the end, but I have 5 things I need to tell y'all. So 1, my story. A little bit on that and Jeepa's purpose. 2, I need to tell you what the strategy is here and why I love what UTB is doing. 3, I'm going to give you a little bit of the big picture. How does this fit in to the big overarching plan on access and justice? 4, we're going to talk about the future. A couple spoilers. For people that don't like spoilers, sign off before, or if you're watching this later, because this is recorded, just skip over the next couple minutes. Once my face is off, you're good, because I'm going to tell you what's going to happen. I'll give you one now, though, so you can quiet it for 5 seconds. If you're wondering whether or not this campaign is going to work, spoiler alert. Yes, you're going to win 100%. I only said 4. So the 5th one, and just to make sure, right, is I have messages. Oh yeah, messages and advice for 3 categories. 1, my people, justice impacted people, got a message for you. 2, allies, people that are watching this that might fall into the UTB category. 3, I got a message for the obstacles. I call them obstacles. There's no enemies. I have one enemy, the system. 1. Obstacles. I'm talking about you, Karen. And whatever your name is, what, Hank? I don't know. The point is, those are the 5 things. So please, Al, totally, you guys are great. Hold me to it. Anybody else in the Q&A, I'll get to it. All right, really quickly, my story. So I was wrongfully convicted 12 years ago. That's where it all started. Based on that conviction, everything that I've done since then has been based on that. The reason I was convicted was because there's a disconnect. I had no power in the field. My family, nobody, none of us could do anything. We were disempowered, disconnected. And that's a reality for most Americans that they don't know. So I looked at why was I disconnected? Why was I powerless, and where was the power? And I saw that the power was in the legal profession. So that's where I decided to go. And 3 years ago, I graduated law school. And the Bar Association, what does it do? Oh yeah, so we provide access, empowerment for other people like myself. We're a voice for the justice impacted community within the legal field. We're the first national organization of justice impacted leaders that works to provide more access to our people in the field. So with that being said, I gotta do a quick thank you. Thank you to Al, Tolu, to all the students that are involved in this amazing, amazing work. Thank you to Legal Aid. Thank you to all the allies that have been there, you know, because our people, this starts with like my belief that the solution to the problems that we're seeing, the solution to the problems of the justice system, it comes from getting people that have seen the problems, having them being actually empowered to work towards solutions with allies. So that's why I'm fired up for where we're going with this. A little bit more on my story, and then we'll get to the strategy. So I was wrongfully convicted, and I decided to go to law school. And along that path, I ran into a number of obstacles. So there was when I say a number, I mean like lots. Anybody that's been through it. I know Jess and Mark spoke to this a lot. But I mean, even names were mentioned. Sean Hopwood. Tara Simmons wasn't brought up, but she was the first justice impacted lawyer that I met. And her story is incredible. We'll get back to that in a little bit, but like, for me, the irony of this all, right, is that I got into law school, I had to work my butt off, right? I took the LSAT, 175 on it. So that's higher, that's 99.5th percentile. I had really good grades, 4.0s. Now, all the time dealing with the obstacles of a re-entering citizen. And here's the irony to me. All these obstacles that I faced were because of, to me, what the most important thing that I brought to the field was. And that's my experience with the system. It's not my grades. It's not my LSAT score. Yeah, I beat you on your test. Yeah, I beat you in school. But you know what you're actually holding me back for? That is the number one thing that I bring. That's the value. That's where I got my character and fitness. And that's why I believe in my people, because I know how powerful that is, and how valuable that is, and how necessary that is for the field. So I've seen it happen now to like way too many people, and I'll add a couple wrinkles in here. So I'm not the only person who's wrongfully convicted that's had issues with the character and fitness, and not just in New York. People like Donald Glassman have had issues. Murray Tankliff is a lawyer now. It took a little while too long for him to get through this. He was wrongfully convicted for murdering his parents. And then when he actually had to work back from that, he actually turned around and decided to go to law school. And instead of opening the doors for him when he comes in, New York, you decided to take a little while before you let him in. To me personally, that's, I'm sorry. I'm sounding a little fired up right now, but Jess, your story made me upset. You know, when I hear it again, it makes me upset. I will get to now, let's get on to the strategy, what I like about that. All right, here's the beautiful thing. When I first heard about that there were students challenging character and fitness, I was like, wow, that's awesome. That's sort of what we have to do with the bar. And why is this challenge going to work, and why is it actually going to be the right solution? Well, they consulted us. You brought us in and asked. So like, and here's the thing, if you're asking like, is this the right solution? How do the people that have been impacted feel about this? I'll tell you right now, we endorse it. We endorse everything you guys are doing. Certainly, you're challenging question 26. Yeah, that should be gone. That's my opinion. That's the opinion, the stated opinion. It's going to be the stated opinion of the Bar Association, National Bar Association. Any question like that should be gone, not just from New York, but from other applications, because every single state has their own bar admissions process. So that's where this needs to go. In terms of the big picture, it's ironic. Everything's hitting at the same time. It's great that we're having this talk. So earlier this week, we did a law school survey with LSAC a little while ago. And earlier this week, they published a report. And the report on the survey is we got 85 schools, asked them about the admissions process, and reviewed the environment overall for justice impacted people trying to get into law school. So now right there's like a look at the problems, and it's the first national overview of the problems that my people face in going to law school. And when I'm talking about this strategy, what I love about it too is that y'all are taking the power, and that's what it should be. So here's what's going to happen with the law school survey as an analogy. So now that LSAC's done that and looked at the problems, who should be the people that are looking at this next? You all, justice impacted law students and allies. So that's where it's being turned over. So we're going to get solutions to that, because there's 3 access points. We got to get into law school, and then we got to get through the bar admissions process, and we got to get jobs. So to me, this is a very necessary step in the process, what y'all are going to be doing with UTB, and you're doing it in New York. And I know history was talked about a little bit already. And to me, it's fitting that New York's going to be that first place, because now we're going to the big picture in the future. Where is this going? You're going to win. You're going to win. Character and fitness is going to be gone in New York, at least question 26, no question about it, very soon. Very soon. And then domino effect. What do? National Bar Association. Yeah, well, because the scope goes beyond New York. What you're going to accomplish in New York, it's going to bleed over to other states. And dun, fall apart. So now messages. And then Al, anybody, cut me off. I don't like to talk for too long. But here are the 3 messages.
Dieter,
1.
Dieter, we love you, and we're gonna sort of move at 2:27.
Okay, perfect. Those 3 messages in 2 minutes. 1, for my people, are you wondering, should I go to law school? If you've been thinking about it, if you've been pondering it, should we try and go into the profession? Yes, 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 you should. It's going to get easier and easier. We've been making waves already. When I mentioned Tara Simmons, she's a senator. And when she became a senator in freaking Washington State, I just talked to her a little while ago. How are you doing, Tara? Are you slowing down? I know that was really hard for you. No, she's not. She's coming with watch what's going to happen over there. We succeed when we get in here. Jess, Mark, beast. Sean, beast. Reginald Dwayne Best, beast. And I'm telling you right now, these law students that we have in Jiba law students, Antonio Reza, Israel Carranza, Colby fucking Williams. We're winning. And the people that are coming along, you have no idea what's in the works. Jody Polk, Jimmy C. Gardner. I could just go on and on with names. We're gonna win. So for the allies, you got 2 options. 1, get your popcorn out. If you're gonna just watch, get your popcorn out, because it's gonna be very entertaining where this goes, where Unlock the Bar goes. But the other option is join, become a legend, become like Tolu and Al and all these other great leaders. Because the history books, I guarantee you, the names of the people that are involved in this, you're going to be in there. But you got to step up to the plate. So those are the 2 options: popcorn or step into the plate. Last thing, obstacles. Like I said, no enemy but the system. But to all the people that are going to be the obstacles, the old, white, racist. Most of you are old and white and racist. Most of you that are going to be obstacles, right? Here's the point. Don't martyr yourself for the system. You've already lost. Don't martyr yourself. Don't take it so personally. This is all just because things have to change. And what the students are going to do, you don't understand how strong my people are, and you don't understand how strong the students are. So with that, I've talked way too long.
Thanks so much, Dieter. No, you gave energy. You gave energy to this. So thank you so much, Dieter, for all the words that you gave. And we are going to move forward with what UTB's top line demands are. So after hearing, all the history, folks' stories, sort of some of the challenges that we're likely going to be facing, we're also going to share, what UTB is asking to do. So our top line demand, I hope everyone can see my PowerPoint screen. My top line demand is to abolish the character of fitness. So it is not transparent. It is capricious, arbitrary, imprecise, discriminatory. It deters those who have been negatively affected by the law, but who also are the folks who know the law best. Deborah Rhodes, the scholar we mentioned earlier, said it's too early and too late. It's too early because no one has even become a lawyer for you to determine whether they would be a good lawyer. And it's too late because folks have already spent all this time, money, and energy on law school before they can get to they're determined to be eligible to be a lawyer or not. So of course, there are some common concerns and critiques to saying to remove the character and fitness, and we're going to go through some of those. So the first critique is, or concern is, if we get rid of the character and fitness, how do we protect the public from lawyers who cause harm? And the response to that would be the character in fitness has never stopped a bad lawyer. Exhibit A, Rudy Giuliani did the 1990s broken windows policy that ended up leading to the arrest of thousands of Black and brown folks. We have Jeff Sessions, who played a key role in the Trump immigration family separation policy. Commissioner Ray Kelly, who endorsed the legality of the Stop and Frisk program, and then also helped implement it. Good old Tricky Dick launched war on drugs and also was responsible for the Watergate scandal. And also, fun fact for everybody, the reason that we have professional responsibility ethics courses in all of our law schools is because of the Watergate scandal. Got J. Edgar Hoover, who is the first director of the FBI. I really don't have to say too much about that one. And then I know this is gonna rub some of y'all the wrong way because people love Chief Justice Warren, but all of our faves are problematic. So when Chief Justice Warren was an attorney general before he became a justice, of California, he was the driving force of the Japanese internment. So when we're saying things like, how do we protect the public from harm? I think we really need to consider what harm is. We like to often focus on individuals and not at systems, and forget that the lawyer is, a creator and an agent of systemic structures. So harm should also be thought of as the discriminatory, if not outright predatory laws and policies and regulations and constitutional decisions that lawyers erect, maintain, and defend, that then serve as the scaffolding for the carceral system, immigration system, surveillance system, imperialist system. So, I used Rudy Giuliani. If the fact that he's done some interpersonal harm is important, but the fact that he's systemically targeted Black and brown communities in New York City through his, the use of his law degree is a problem. Same thing with Ray Kelly. Same thing that if you're a lawyer for Enron and you defended their practices that led to the 2008 Great Recession that destroyed the entire American economy. So you're not protecting people. And the fact that, lawyers protect Facebook as they continue to aggrandize the surveillance state. Or if you protect ExxonMobil as they poison the planet. Like, these are all ways of looking at harm that we really don't consider. The next question, if we get rid of the character in fitness, how do we as marginalized people protect our communities? So this is a really important concern that, when we get rid of the character in fitness outright, the negative effects will only serve to leave marginalized communities more vulnerable to potentially unscrupulous lawyers. And while that's important, I think it's really hard to say that state accreditation is specifically what's protecting communities of color, other marginalized communities. Firstly, some of the best lawyers are jailhouse lawyers, right? People who know the law in and out, live the law, aren't accredited by the state, but are literally doing the work to protect marginalized communities from state abuses. There's also a need to keep aware that, we're worried about whether or not there are, how are we going to protect folks from lawyers? But I think a lot of marginalized communities don't even have access to lawyers when they affirmatively need them. The legal profession, there's no right to a civil lawyer. And so a great majority of Black and brown people, when they do need them, can't access them. Also, the legal profession mostly serves wealthy white folks or are servicing corporations that then go and prey on marginalized communities. And that's what the current, with the character in fitness currently in place. So, if you're protecting the De Beers Diamond Company as they use child soldiers to mine their diamonds, you're not protecting marginalized communities. If you're protecting Jeff Bezos when he, Amazon stole tips from workers, you're not protecting the community. Another critique is this argument is futile because the character in fitness process rarely, if ever, excludes anyone. Well, we know that's false. We know people obviously get excluded, but I think what's also important is that we have to think about, we have to broaden our understanding of what exclusion means. So exclusion isn't just at the gates of the bar admission process. We mentioned earlier, law schools are reflecting, the law school applications are reflecting the exact questions that are on the character in fitness. So a lot of people are self-selecting out of applying. So that's an exclusionary matter. But then also a lot of people are getting rejected at the gate. And nobody wants to spend, 3 years and $250,000 if they aren't sure if they're going to be admitted at the end of the day either. Then also number two, if the character and fitness process doesn't exclude anyone, then that's great, but then literally what's the point? And then lastly, if we get rid of the character and fitness, what will we have to replace it? So the answer to that is honestly maybe nothing, and that's okay. We need to stop evaluating people at a moment in time and really reevaluate what metrics we actually decide are important to be a good lawyer to practice law. And then, when we figure out those metrics, maybe we shouldn't be penalizing people for not meeting those metrics, but rather, if law school continues to exist in the way that it does, we should be teaching liberatory principles, anti-racism, anti-capitalism, anti-fascism, anti-imperialism as the core part of being a lawyer. And then whether or not we agree with them, we also have a bunch of other measures currently in place that either teaches or responds to ethics inquiries. So like, again, I said, there is the law school application of the front end, which again, we don't agree with that. But then we have professional responsibility courses. We have the MPRE, which is the ethics exam that you have to take. Orientation to profession, which is another set of ethics videos you have to watch before you get admitted. And then we have post-admission conduct discipline. So it really begs the question, if we have all these measures and you still have lawyers harming people, maybe there's not something wrong with the people, but maybe something wrong with the profession itself. So I'm gonna kick it to Al to talk about sort of UTB's next steps, what we're working on, our advocacy areas, and how folks can get involved.
Thank you, Tolu. So you've already heard a little bit about this, about all the work that's swirling around that's been done by a lot of people. We're going to talk about specifically what Unlike the Bar, some of our partners and current members and future members are coalescing around. So these are things that we've been discussing since about a year ago with the entire coalition in different parts of the process. And obviously, one of the things that you are probably most familiar with now is our specific advocacy around question 26. This is one goal, and as Dieter said, an immediate one. It is a very concretized, explicit, blatant, shameless example of the exclusive, racist, xenophobic, just problematic, elitist, system that we have. And it's one that is extremely, extremely important that we knock down as soon as we can. And one of the ways that we are doing that, as well as all of our work, is through school and student advocacy. So that looks like us pressuring the deans of our law schools because they are in many ways part of this system. Just a quick anecdote, when these conversations have happened in the past about changing the questions on the bar, on the character and fitness, the state and the entities that make these decisions are getting pushback. Not from, I don't know, these, if you imagine some evil people behind masks, they're getting pushback from the deans of law schools who are saying, we want to ask these questions on our character and fitness. These are the people that we need to advocate for. These are people who have a lot of control over the system. That's one of the reasons why it falls to students like us to pressure deans of law schools, to administrators, the people who are the constituents who have the power in the system. And one of the ways that will work is through a petition, something we've been working on. Activism takes a lot of different faces and shapes in the virtual world. One of the things we've been working on, instead of direct actions and the things that we'll hopefully be able to do once the world goes back to the way it was before, but in the virtual world, one of the things we've been working on is a petition, specifically to create a petition with all the demands to the Court of Appeals, to the appellate divisions, and then to the administrative board of the court system and the New York Board of Law Examiners, for some of the different powers that be that control this, to use their discretion, enormous discretion in all these cases, to dramatically change the system. And that's one of the things that we've continually been working on. We want to make sure it's representative of different people, different thoughts, different arguments, and has as much buy-in and input reflected as we work forward. And it's also similar to the 15 different law schools, each having different deans, different politics, different histories. We want to make sure that there are also petitions and advocacy materials in each school, whatever works best for the school. That's one of the reasons students, but also people in organizations, upstate, downstate, wherever you are, you know your people the best, you know your systems the best. And so we want to, the petition there'll be a couple of different petitions, and that's something we want to be continually moving and working on with people. And then obviously publishing and pushing with people. And then one of the other things is a request for data transparency. As we said before, this is a system that's protected in many ways by the silence around it, by the enormous power they have over the system itself, but also over the information about it. One of the things that we've been demanding is that the court needs to release the numbers of how many people and what demographics of people have been rejected, as well as the demographics and the length of the process for applicants who were accepted. So a full release of how members of the character and fitness committee are selected is something that we also really, really want. And we want to know who is on the character and fitness committees for how long, and what that process looks like to get on there. And then another thing that we've been working towards, and I'll discuss this a little bit, but is having people who are actually affected by the legal system determine who are good lawyers. Something representative in this democracy for a change. And one of the things that's come out of the recent uprising is there's been a series of commissions and working groups and committees and so on to evaluate, for example, the bar admissions process in general, but also to evaluate police brutality. These are some of the things that we are looking for the Attorney General's office, from the bar associations, working groups to focus specifically on this issue. And then we are also, another advocacy goal is to have a hearing with the character and fitness committees themselves. And that can advocate and advance a lot of the different roles and a lot of different goals that we've been pushing forward. And one other that I discussed a little bit is that we want to have impacted and marginalized individuals be guaranteed space on character and fitness committees, so that it's not just the boilerplate, old white faces that run everything else, but with an institution like the legal profession that is supposed to be, that is the only group that has the power to represent people in legal spaces in the face of the enormous power of the state and the enormous violence that it can inflict. We want people who are actually impacted by the realities of these systems to be guaranteed space on the character and fitness committees to the extent that they continue to exist. And then we also, as I said before, we want to demand that similar questions, and there are questions, all 15 law schools in New York has a question similar to question 26 on their law school applications. I think Buffalo has the least terrible one, but I know NYU's is awful. And we have been demanding, student activism has been going on this issue for years already, but we want to advocate that and get this done, to get these questions off law school applications, because it's absolutely just indefensible that we are continuing to ask these questions that are illegal, as Melissa was saying, but moreover violate all these high-minded concepts of what law schools are supposed to be in a democratic society. As we see statement after statement, corporate signing statement about how we oppose racism and so on. We need that to come home. We need that to be real. We need that to be reflected in not only the student body itself, but in the systems that perpetuate why so many law schools, student bodies don't represent our society at large and the people who feel the harms of the law. And then another thing is potential legislation and litigation. So as we said before, there are various laws that hold up the character fitness process. So a legislative change is part of the future that we envision. And there's also litigation. This is something that can be litigated. Obviously, there are laws that say this is illegal. So litigation should be able to knock out some of that if we have a just legal system. But regardless, all of this work is going to come together. And I want to say, Peter already talked about this a little bit. Melissa already talked about this a little bit. Tola already talked. There have been a lot of really successful movements in this space before. There's an upward trajectory that we are continuing to try to push up. So last year on February 26th, for example, the prior questions about mental health totally discussed were removed from the application. As she explained, there's still this catch-all question, but progress is being made. We have a lot more to go. Similarly, there's a citizenship question on the bar exam, on the character and fitness application. That was removed in January of 2021, just recently. There's a long way to go, but this is the type of movement, this is the type of work. These are the people, the system impacted people, allies, the people, connected people. This is how we can move forward on these goals so that we'll no longer be complicit in this system. and so that we can have something that's actually approaching justice in our justice system. And then, so that's an overview of a lot of different work. It's changing, as we said before, this movement is growing. And you may be wondering how to get involved, because that's a big part of what today is about too. We would love everybody who's involved here. You are this movement. If you care, if you took these 2 or an hour and 45 minutes already on your Saturday, it's because you care, and this work is important to you, and we want to get as much of your involvement and engagement as possible. And so there are a lot of different ways that you can get involved. First, we have a Twitter at unlockthebar.ny. We also have an email. You can email us at unlockthebar@gmail.com. Our website is unlockthebar.org. We have a Slack, and if you fill out this little tiny URL for UTB contact right there and give us your information, we'll add you to that Slack. We also want to invite everybody who wants to. We've already received a bunch of emails and comments sharing people's stories, how they're affected by this system. And we want to make sure that people have the power and the platform to share those stories. So if you go to, and we'll post all the links for this in the chat. Actually, let me do that right now. And we'll send them out by email also. But you can share your stories with us in a story collection platform that we created. And then we also, if you go to this link I'm putting in the chat right now, there are links to the character and fitness application itself, so you can get the information and the forms that explain what that looks like, so you can actually understand what you're going to face and what the system is that we're trying to knock down. And you'll find the link to the application itself there, as well as some of the information Tolu talked about. We want to also shout out again Roland Acevedo, who wants to be available to answer any questions and offer any advice he can. His email is there on the slide, as well as in the link I sent you in the chat, which will also be emailed out, legal@racevedolaw.com. And there are also some of the other resources that we discussed. So Debbie Mukamal's Unlocking the Bar report, Carol Langford's work, Tara Simmons' work, her law review article, Transcending the Stigma of a Criminal Record, our proposal to reform state bar character and fitness evaluations. We are people associated in the legal world. There's a lot of really great scholarship on this. And that is all available in the links document and will be sent out by email. And so now, as you may be able to tell, we want to make sure this is open as much as possible for questions and answers for people to tell their stories. We originally wished this could have been an in-person discussion, but then a Zoom discussion would have been preferable. Just technologically, we had to make it into a webinar. We want to make sure that there's space for people who have any questions, or if you have a personal experience you want to share, anything like that. The rest of our time today until 3 is open to that for the floor. And to start us off, we've already received some questions from the Q&A, and I will read, just because our first one is from somebody anonymous, but if you want to step up and ask your question, we will spotlight you. But our first question comes from somebody, somebody anonymously who asked, is the court's ruling in Schwer that a rational basis is required good for us? And so for non-lawyers or people who haven't taken common law or forgotten common law or whatever, rational basis is a very relaxed legal standard. And so I'm wondering if any of our wonderful panelists wants to take that question about the reflections on the court's ruling in Schwer.
I may have misspoke. I don't know. I didn't intend to say rational basis. It's a rational connection. So it's not using any of the equal protection clause language. And so in some way that is pretty beneficial to us. If it's a rational connection, we can try and argue that it's not rationally connected. And at the end of the day, the petitioner Schwer, the Supreme Court ended up ruling for him in that case, saying that there is no rational connection for the New Mexico Board of Law Examiners the next New Mexico Character and Fitness Committee to utilize his arrests, his involvement in the Communist Party, and his aliases against him.
Thank you, Tolu. Okay. And then next, we have a question from Carly Summers. So if we want to spotlight Carly, if you want to ask your question, feel free. If we can spotlight you.
Okay, can you guys hear me? Okay, great. Yeah, hi, I'm a staff attorney at Nassau Suffolk Law Services. I work in our reentry project, so I do a lot of post-conviction relief. And my question for our panelists is, do you think that law schools have an obligation to tell students up at the beginning, I don't think that you're going to pass character and fitness? Do you think that that's something that you would have liked to have known, maybe?
I'm happy to answer that or give a little bit of an answer. So I'll give you what Sean Hopwood said on this. Don't make that decision, deans. Don't make that decision, law schools, because they don't know. They can't tell people whether or not they're going to be admitted to the bar. Law schools haven't looked into it enough. I mean, we have like I'm happy to share the report. I know, like, I think Tolu and Al, you might have that report, but like the law schools don't know enough about, first of all, they don't know where you're going to practice after you get out. They don't know enough about the process because, like we said, it's very nebulous. There's no, it's not clear what the bar admissions is going to do. So I think what they have an obligation to do, what law schools should do, is ensure that when you are admitted to their school, that they are equipping you with the tools that you will need to actually practice. Because right now, that's part of why law schools are like not admitting people sometimes, because they're making the decision in advance. They're saying, I don't know if they're going to be able to practice. I don't know if they're going to be able to contribute. So like, let me make it very clear. Law schools, look at us. Look at what we do when we get out of your schools. We win. That's all we do. We win at the highest level. So to answer your question, no, I don't think law schools should be telling people whether or not they're going to be able to practice or contribute, because they've been wrong. I was told. It was made very clear to me that I wasn't going to be able to do anything, not just by the law schools, but by lots of people. And so far, they've been wrong.
Okay.
That's my opinion.
No, I wonder if it's fair to maybe not even just sit down and have a conversation like this with a student, you know? Because the law could change in 3 years, but there's a chance it couldn't. So that's, I guess, would people prefer to know from day one, or?
Oh, they should know. Yeah, like, so there absolutely should be, and in the report, that's all covered too. Like what we asked was like, when do you talk to them about character and fitness? How do you do it? Do you let people know how they're going to have to like deal with the process? So like all that should be dealt with by the schools. Just specifically, I don't think they should say that because, more one, like I said, they don't know. Like, quite frankly, because they're not on the character and fitness. Like, who's going to do that at the law school? You know, they don't know.
I'm just going to jump in real quick. I agree that I don't think the law school should be telling anyone they shouldn't, they won't be admitted because they don't know. But I think the law schools have an obligation to provide support to the students they do admit, however they can. As I mentioned, I had a small issue with something I had on my law school application, and they supported me. You know, they addressed it, they saw fit, and then as they needed to do, and made sure that I had a strong application going into character and fitness. And they also gave me a lot of opportunities in the law school to show who I am and that I would be, that I had the character and fitness to be an attorney. So I don't think that law schools, even I mean, who gets to really make the decision, right? You know, like, is it one dean? Is it a committee? I think it can get really complicated to expect the law school to make that decision for a character and fitness panel that most of them, if not all of them, won't be sitting on. Yeah, and I just think it creates another barrier. And as you said, there are changes coming around. So is it better that I go to law school and wait till those changes, or do I wait till those changes get made and then go to law school? I think there's just too much on the table. I think they have a duty to inform the prospective students. I met with some people at my law school beforehand. I actually think I met with them before I started my application in terms of the process of being admitted to practice law. So I don't think that law schools should be in the business of informing or telling people they won't be admitted. I just think they have an opportunity to support their students along through the process and inform them of the difficulty that they're going to run into in the process. Is that helpful?
Yes, thank you. I think I didn't ask the question right. I think that it should be, should the law schools have a conversation with the students before they start? I think that what you guys are saying is it should at least be a conversation.
I think that goes along with the support. I mean, for anyone. I mean, I have friends who have been denied because of the debt they had. You know, as Jessica said, that one of the things they talked to her about. I think they do have a duty to inform students about that. Students want to, because I also know that a lot of my classmates knew they weren't going to run into any of these issues and didn't want to hear anything about it really. But for people who maybe they see in their law school application who have stuff on their application that may raise issues, that they know may raise issues, they should definitely have conversations about it. I think that's part of their responsibility in supporting students and graduates through the process.
Thanks, guys.
Thank you.
Thank you for your question, Carly. And thank you, Dieter and Mark, for answering. And we have one more question from Max. I don't know if you want to jump up and ask your question. I would love to see your face, but if not, I can ask you a question. Let's see if Adia can jump. Here we go.
I think Melissa kind of answered it mostly. I was just curious about whether there were other examples of you know, other professions having the sort of character and fitness requirement, doctors, social workers, educators. And I think, you know, Melissa kind of spoke to how they certainly aren't violative of New York laws in the same way that the character and fitness questions do. So I don't know if there's anything else. I'm not familiar with like other professions and how they regulate, so to speak, their and sort of their professionals, but I was just curious if there was like a comparable situation. Not that that would make it better, but I was just curious.
Yeah, I mean, almost every licensing agency in New York State is required by law to investigate the character of applicants for the license. And almost every licensing agency in New York State views that character and fitness requirement to involve investigation into criminal record in some way. So the bar is not unique in having a statutory character and fitness requirement. What the bar is unique in is being incredibly invasive. There is no other licensing agency in New York State that is as invasive as the New York State Bar. And there is no other licensing agency in New York State, with the exception of gun licensing agencies, which are exempt from that part of the state human rights law. There is no other licensing agency that expressly says that they do not think they need to abide by this law. And it's that uniqueness. It's not that the character and fitness requirement is unique. You know, it's that they take character and fitness to such an extraordinarily invasive level. And I think that a lot of the character and fitness requirements for the various licenses need to be challenged in some way. But the bar is truly unique in how far it goes. I don't know if that answered the question. I mean, so, and just to very specifically answer it, nurses are licensed by the state education department, social workers are licensed by the state education department. There are every single type of profession that you just named has a licensing regime and has a character and fitness process, but it is a character and fitness process that does not involve the same level of invasiveness and illegality that the bar does.
That's super helpful. Thank you.
Thank you so much, Melissa and Max. And then our last question is about what UTB is doing with regard to immigration issues.
Yeah, I can take that. So what's really interesting actually is that as of January 4th, 2021, so not too long ago, about a month and a half ago, the immigration question that was on the character and fitness application got removed. And it was specifically stated essentially that the citizenship is not a requisite for admission to the bar under the New York law, and it has been determined that the question should be eliminated. And that came from the Chief Judge DiFiore, who is the Chief Judge of the Court of Appeals, so it's the highest court in New York. That doesn't necessarily mean people are out of the clear. And in general, because we're trying to remove the entirety of the character and fitness application and process, that would necessarily also be affecting folks in all systems. So folks who have also been touched by the immigration system as well. But we're definitely interested in incorporating a lot more story, energy, and direction from folks who have been undocumented or are currently going through citizenship issues.
All right, thank you, Tolu. And that's all of our questions. And I'll pass it back to you to close out. Okay, great. All right, well, we are gonna close out. Thank you, all of our panelists, both here and not here, for joining and sharing, and particularly those who shared sensitive and traumatic experiences. Really appreciate that. Thank you to all the attendees for coming and spending 2 hours on your Saturday. If there are any further questions for any of the panelists, you can send that to our Gmail and we'll connect you with the panelists. And also, if you have any further questions for us, you can connect with us through our Gmail. And I want to just thank all the organizers of the event. So shout out to Al, Amelie, Colby, Hadia, Johari, Lizzie, Maya, Sophie, and Yasi for making this event happen. And thank you to all the students in CUNY, NYU, and Columbia for the efforts so far on this issue. And we hope to hear from everyone soon. So thank you so much and have a good Saturday.